Good afternoon and welcome to ABC Baltimore's presentation of Senate Bill 853, General Contractor Liability for Unpaid Wages. My name is Greg Currey and I'm joined today by Doug Seitz. Doug and I are partners at Wright Constable and Skeen. Doug and I both work extensively with the construction industry. Doug focuses on the general business matters involving the construction industry, from contract issues to collections to litigation, whereas my particular focus is on the employment issues that construction companies face. Today we're going to be going over the Senate Bill 853, which takes effect on October 1st, 2018. Doug's going to begin by talking about what Senate Bill 853 actually does and what it is, and then I'll go into a discussion of the wage payment laws and how those are affected by Senate Bill 853. And then finally, we'll give you some tips on how to handle the business issues that are going to arise from Senate Bill 853 moving forward.
So what is this new law that goes into effect in 11 days? It's a relatively new concept that requires GCs to ensure that all people working on a construction project are properly paid. In other words, if the guys erecting the scaffolding on a project don't get paid by whoever employed them, then the general contractor on the project could be held liable for those unpaid wages. Is this new law fair? Do you think it'll make GC's job more difficult? Do you think that GCs will try to pass this obligation down to the lower tiers? If you said yes to all these questions, then you're thinking along the same lines as Chief Judge of the United States District Court for the District of Maryland was thinking 60 years ago when he was considering the complexities of a large construction project. You'll see there on the screen his quote, and I think Chief Judge Thompson's thoughts ring true today as much as they did 60 years ago. This screen is a fairly accurate summary of the new law. The law makes a general contractor on a construction project jointly and severally liable for violations of the wage payment and collection law committed by any subcontractor on the project. So let's break these segments down. First, let's talk about general contractor. What is a general contractor? There is no definition in the Act, Senate Bill 853, as to what is a general contractor. But what is a subcontractor? Again, the law does not define this important term, subcontractors. There's no definition in it. Are these terms defined elsewhere? Well, they're not defined in the labor employment title of the Maryland Annotated Code, but I did find definitions of them in the Maryland Mechanics Lien law. Whether these definitions that are in the Maryland Mechanics Lien law or not will be applied by a court of law interpreting 853 is a question that I can't answer.
Significant because under the law they talk about a general contractor and a subcontractor, and while in the industry there's a general understanding of what those terms mean, legally someone that we don't think of in the industry as being a subcontractor or a general contractor may be considered a general contractor.
That's right. That's right. I mean, because the term is not defined, it's open to interpretation by any judge that is presented with this issue, and therefore you have the possibility where you'll have rulings that are inconsistent with one another because of these undefined terms. So let's look at the Maryland Mechanics Lien law and see what it talks about it. The Maryland Mechanics Lien law does not define general contractor like Senate Bill 853 describes the person that's going to be responsible for these unpaid wages, but it does define contractor and subcontractor. So a contractor means a person who has a contract with an owner. So I posit to you, under the definition in the mechanics lien statute, is possibly a construction manager a general contractor under Senate Bill 853? I would argue to you that if the court uses the definition in the mechanics lien law, they could easily find a construction manager to be a general contractor under 853. Whether they will or not, who knows? It's open to interpretation. So let's look at subcontractor. So subcontractor means a person who has a contract with anyone except the owner or his agent. Again, it's a very broad definition, and quite possibly a court interpreting 853 would, if they used that definition as to what a subcontractor is, could hold a general contractor responsible for the unpaid wages of all the suppliers on the project. That opens a whole can of worms that would create an incredible amount of potential liability for a general contractor. Again, what the Senate should have done was they should have included in this law definitions of these terms so that there wouldn't be no ambiguity. But there is a huge ambiguity with this law, and only time will tell how this all ferrets out. Finally, what is a construction project? This is the only critical term in the statute that's actually defined, and it's not defined in the statute itself. It refers to another law under the Labor and Employment title, which defines construction services. Okay, so construction services includes the following services provided in connection with real property. And there's a list of 8 that you'll see there. And it starts out pretty clear: building, reconstructing, improving, enlarging. But then we get to some rather, specific terms: painting, altering, maintaining, and repairing. Now, with the exception of painting, I would suggest to you that a lot of these aren't traditional build a new building construction type things. So, and how they're defined could broadly expand the scope of this law. For example, would a property manager that hires grass cutters to cut the grass in a project be considered a general contractor under this law? The property manager has a contract with the owner of the property, and he's hiring somebody to do maintenance on real property. Ergo, I think it is conceivable that a plaintiff's attorney would argue that the property manager is a general contractor under this act, and that the property manager could be responsible for the unpaid grass cutters. So again, we do have a definition, but it's a very open definition, and I'm not really sure how courts are going to come out on this in light of the comments that Greg will make a little bit later in the presentation. Okay, so let's talk about indemnification. A subcontractor that fails to properly pay its laborers may have to pay the general contractor if the general contractor is found liable for those unpaid wages under this law. There are 2 minor exceptions to the law that gives the general contractor the right to sue the company that did not properly pay its laborers. They are listed there, and one is that if the general contractor didn't pay the money it was supposed to pay to its subcontractor, and a result of that, someone down in the lower tier didn't pay for their labor, then there would be no indemnification there. And the other is if an indemnification agreement exists between the general contractor and the employer that failed to pay the proper wages to its employees, then the indemnification under this statute wouldn't apply because there's already an indemnification agreement there. All right, now I'm going to pass it over to Greg.
And so, as we mentioned, the law takes effect October 1, 2018. This doesn't give a lot of time for people to prepare, and so you need to sort of, as the courts are developing, as they're reaching decisions on the law and as they're interpreting things, I think the law will continue to be sort of evolve over time. So, that October 1 is the first effective date, but I think we're not really going to get a lot of answers until well after that. So what I'm going to talk about are actions under the wage payment and collection law, because Senate Bill 853 talks about the general contractor is liable for the subcontractor's failure to pay its employees. But what does that really mean from a practical standpoint and from a legal standpoint? The Maryland Wage Payment and Collection Act applies to any claim for wages, not just a failure to pay. It includes unpaid overtime, improper deductions from wages, failure to timely pay wages, and for employees that have been misclassified, whether that's as independent contractors or as exempt employees, i.e. salaried employees who are not entitled to overtime. Under the Maryland Wage Payment and Collection Act, it's essentially a strict liability statute for employers. And so a lot of the contractual defenses that you may otherwise have on a construction project, they're not going to apply to a claim brought under the Maryland Wage Payment and Collection Act. And so if you have a defense of, well, this was a pay when paid contract, the owner didn't pay me, and so I don't have to pay my employees, that doesn't apply. If you have a contract between the general contractor and the subcontractor whereby the subcontractor is prohibited from having employees work overtime, that's not going to prevent an employee who actually works the overtime from bringing the claim. A situation comes up frequently where employees have agreed to alternate compensation models. We're talking about situations where an employee agrees to work for a flat rate for a full day, or where an employee says, okay, look, I understand you can't afford to pay me the overtime premium because of the way the finances on this project are going to work, but I need the money, I need the hours, I'll work that time straight time. Unfortunately, the courts don't uphold those kind of arrangements. And so I've dealt frequently with employers who are being sued by a former employee, and they're pulling their hair out saying, why is this lawsuit moving forward? We agreed that they would work straight time for any overtime. They asked for the time, they wanted it. Why do I have to pay them this time and a half? And why do I have to now pay them treble damages because they agreed to it? Unfortunately, the courts don't accept that defense. Those agreements are void against public policy, and the courts will not enforce them. Undocumented workers, again, whether or not an individual is here in the country legally or here working legally, is not a defense to a Wage and Payment and Collection Act claim. If an individual performs work for you, it doesn't matter where they're from, it doesn't matter if they're here legally, you have to pay them. There are a couple important areas to watch for, particularly in construction projects, that come up a lot. One of the things is whether or not employees are properly being paid for travel time. There's sort of three subsets of these kinds of cases. First, travel from job site to job site. The employee starts off their day at 8 a.m. and they're working at site A. At noon, they leave site A, they drive for an hour to get to site B, and then from 1 to 5, they work at site B. And so you as the contractor may say, okay, well, they only actually worked 8 hours, so I'm going to pay them for 8 hours. Wrong. Once the once they start working at one job site, any travel from one job site to another job site is compensable time. Second issue is it arises sort of out of when the day starts and ends. Frequently, employers will pay their employees starting at when they actually get to the job site and start working on the project, because that's what they are getting paid by the general contractor for. That is not what compensable time under Maryland or federal law is. If the employee comes to your yard or your warehouse, they pick up tools, they help load trucks, and then they all drive together to the job site. If they've performed any work while at the yard, they need to be paid starting when they get to the yard. The way around this obviously is to require that employees report, except for those that are absolutely necessary to load trucks, have them report to the job site directly. Similarly, that gets into mandatory carpooling issues. Frequently, you'll see situations where the foreman has a truck, and so he goes around and picks up his crew on his way into work. They all ride into the job site. They either ride into the yard or the job site together. And so as an employee, you are saying, well, look, they're voluntarily doing this. I don't have to pay them for that. That's correct. However, if as a condition with providing that foreman with the truck, you require him to pick up the other employees and drive them in, then you do need to pay him for the time that he spends picking up the other employees and driving them to the job site. To be clear, you only need to pay the person who is required to drive. You're not required to pay the passengers for the time spent simply riding in the car. Another important issue to look for are meal breaks. Frequently, companies will have set, particularly when they're dealing with employees that are working off-site where they don't have a time clock, they'll make automatic payroll deductions for meal breaks. However, for a meal break to not be compensable time, the employee has to be completely and fully relieved of all of their job duties. And so if an employee is working through their lunch, you need to pay them for that time. This comes in a lot near the end of projects when you're getting up against a hard deadline and people are told, I don't care what you need to do, you need to get things done, so people work through lunch. But the payroll system isn't updated to stop making that automatic time deduction, and so people are being shortchanged by a half an hour or an hour a day. Unfortunately, over time, these half hours and hours add up. There's a 3-year statute of limitations. Employees can bring collective and class actions under these claims. And so if you have 100 employees over 3 years with an hour a day, they can then get treble damages and attorney's fees. Something as little as failing to pay somebody for $20 in a given workday can balloon to a $500,000 to $1 million claim when you aggregate all the employees and they start getting their attorney's fees involved. Another issue that comes up are employees not accurately recording breaks. If you have breaks where employees are fully relieved of duties, those need to be completely and accurately noted on any timesheets or payroll records so that employees are accurately paid for any time that they're actually working on the job site. Another big issue to look for are misclassification issues. As a general contractor, you need to know how your subcontractors are classifying their workers as whether they're exempt or non-exempt. Because not all supervisors, just because you pay them a salary, are going to be exempt. A lot of you are probably now asking, exempt, what are you talking about? I have salaried foremen who I don't pay overtime because they're salaried. Under federal and state law, for an exempt employee is an employee who's exempt from the overtime requirements of the Fair Labor Standards Act or the Maryland Wage and Hour Law. What that means is those employees are paid on a salary basis and their job duties meet one of the recognized categories where they're permitted to be paid on a salary basis and be treated non-exempt and be treated as exempt. You can pay an employee a salary, but that doesn't necessarily make them exempt. And one of the issues in construction projects that's constantly being scrutinized by the courts is whether or not foremen are properly classified as exempt or non-exempt. Because just because they supervise 2 or more employees doesn't make them an exempt manager. they need to have significant authority over the employee's work life. So they need to have the ability to hire and fire people. They need to have the ability to make significant disciplinary actions. And so if you have like a working foreman that also supervisors a crew of 3 people, you need to take a close look at whether or not they're properly classified as exempt. The other big issue in the construction industry is misclassification of independent contractors. Maryland has a Workplace Fraud and Prevention Act that requires on construction projects, if you classify an individual as an independent contractor, that you provide him with a pretty detailed notice that explains that they're an independent contractor, what that means, how you've reached that determination, and it gives them that information so that they understand what they're accepting by agreeing to be an independent contractor. Presumptively, if you have not provided somebody with that notice, you are deemed to have improperly classified them as an independent contractor according to the Department of Labor licensing and regulation here in Maryland. And so if you have subcontractors that supplement their workforce with independent contractors that they're bringing in, you need to make sure that they're following all the requirements of the Maryland Workplace Fraud and Prevention Act. All right, so now we're going to talk about, now that we've scared you with the vague statutory language and the fact that you're going to have to pay treble damages and a fortune in attorney's fees, well, how are contractors going to protect themselves under the new law?
Well, Greg, let's just take a break here for a second. You've indicated the treble damages and the attorney's fees and the fact that these types of cases can get very expensive. Do those exorbitant damages apply to a general contractor who has nothing to do with how the employee or the laborer got paid? Do they follow through? They were normally awarded against the employer of the laborer, but will those damages also be awarded against a general contractor under SB 853?
That's one of the problems with SB 853 is that it's not clear what will constitute a bona fide dispute for a general contractor who the employee is seeking to hold liable for the subcontractor's failure to pay. And the way the law is written, it appears as though the legislature intended that the general contractor will be subject to the same, they'll essentially stand in the shoes of the subcontractor and they won't get any additional defenses. And so that if an employee of a subcontractor brings a claim, you're likely going to be on the hook for the treble damages and attorney's fees, at least until a court comes along and says, no, this isn't what the legislature intended. We're not going to hold you responsible for the treble damages and attorney's fees because you either had no knowledge of the failure to pay or you had taken reasonable precautions to ensure that your subcontractors were paying their employees.
Okay. And I guess my next question is do you see this as the next sub-cottage industry for plaintiffs' lawyers? In other words, do you see plaintiffs' lawyers actively advertising near work sites and things about these kind of cases to kind of drum up business?
Well, I don't know that would be a change. Quite honestly, plaintiffs' attorneys have always targeted the construction industry because of a number of the issues related to misclassification as independent contractors, paying employees on a day rate, and so on and so forth. What this will change is through this legislation, the Maryland General Assembly has given plaintiffs' attorneys a whole new set of deep pockets that they can pursue. Frequently you can settle, when you're dealing with a smaller subcontractor, you've got limited funds. And so you can settle these cases for a little bit less than you would otherwise. You're not settling for the full value of the claim because there's a recognition that there may be an inability to pay. And so you sometimes can get a discount and save some money that way. But if now the plaintiff's attorney can say, oh, well, if I take this case that may not have a prospect of a great recovery against the subcontractor, well, for example, random subcontractor A may not have the money to pay this judgment, so maybe I won't take the case.
But the general
now,
contractor,
they say, oh, well, Whiting Turner can pay,
right.
so I'm going to take this case because I can go after them. I'm not limited to the smaller outfit that's probably operating on a smaller budget and has less ability to pay a judgment.
Sure. So you think it's reasonable to predict there'll be more litigation involved in this area of law based on this change in the law?
I think it's certainly it's already been a hot area of law, and one that plaintiffs' attorneys clearly see as a lucrative area to pursue. And I think that this, by giving another group of companies that they can recover from, it's another set of pockets they can raid. So I think that we can really, I think we can expect to see more of these claims. There's really no reason not to pursue these.
Okay, well, tell us about what contractors and subcontractors can do to protect themselves. We're saying subcontractors them as well because of the indemnification issues that are highlighted in the Act. Will clearly trigger the concept to general contractors to ensure that they get indemnification from their subcontractors for this new exposure that the law creates.
Right. So the first thing is obviously greater vetting of subcontractors. And at the end of the day, this appears to have been the primary motivation behind the legislation. There was a big union push for this legislation because if a general contractor was going to be potentially held liable for the actions of the subcontractors, the firms that used a unionized workforce they would have had a better history of paying their workers. You can ensure, through the collective bargaining agreement, there's greater history, and it prevents upstarts from coming on and challenging them. And so one of the things that you're going to want to do if you're hiring a subcontractor on a project, whether or not you are a general contractor or a subcontractor hiring a sub, is you want to have a survey or questionnaire regarding the prior history of wage and hour law compliance. That survey or questionnaire should include a couple things. One, history of litigation or settlements that the company has made resolving wage and hour claims, but also you'll want to get into, for any workers that are going to be on the project, how they're being paid. Are they exempt or non-exempt? Are they classified as independent contractors? What are their hours? Are they going to be reporting directly to the job site, or do they go to the yard before they show up on your work site? You're going to want to know all of those different pieces so that you can make an informed decision of, okay, when the subcontractor is on my work site for 8 hours or 7 hours, are they accruing overtime liability by virtue of the fact that the employee is actually showing up 2 hours earlier at the other job site? You can also require disclosure of company financial status. An agreement to indemnify is only as good as the financial condition of the company entering into that agreement. And so if the company that's indemnifying you has no money, that's a worthless agreement. Finally, if you're a subcontractor yourself and you know that a general contractor is going to be asking you for these things, you should conduct your own wage and hour audit so that you can present information to prove that you're paying all of your employees the required wages, that you don't have outstanding liabilities, so that a general contractor can feel comfortable hiring your company, knowing that if they hire you, that your employees are not going to be coming after them down the line. This all comes back to trust but verify. You've gone out, you've asked the subcontractor for this information, and they've given you a big pile of documents. There's another source that you can look at to find out what's out there. And so you're going to want to review public records, including court databases, for information on possible prior wage and hour law infractions, or even just in a history of employee issues. And so if you see a subcontractor being sued by individuals, you can know, oh, this may be somebody that I'm going to be taking on some risk if I bring them on board. You can ask for prior payroll runs and information from their accounting or payroll company, and then you'll also want to get copies of any notices to independent contractors under the Workplace Fraud Prevention Act.
Okay, so I'm going to talk about another way that contractors and subcontractors can try to protect themselves about this new law, and that is in your subcontract or your subcontract. You want to try to strengthen the language in these documents so that the risk or the liability that you are incurring flows down to whomever it is that you contract with, and to ensure that they do their job in policing their subcontractors to ensure that wages are properly paid. Indemnification should therefore be written into both of these types of contracts, and specifically the indemnification provision should include claims made under the Wage Payment and Collection Act or any other statutory regulation that imposes this liability on a general contractor. And that next question is, should you control who your subcontractor contracts with? The answer is yes. If possible, you should try to control the people, the entities that are a tier below you, 2 tiers below you, 3 tiers below you, if you possibly can. This gets back into what Chief Judge Thompson was saying. How does a general contractor control all these aspects of a huge construction project? Well, the one thing is that you could have written into your contract that you have a say in the subcontractors that your contracting party hires. So that's something to consider. Then you should insist on certified payroll reports from everyone down the line. In other words, if you're the general contractor and it's a 4-tier job, then you're looking for certified payroll records from your subcontractor, the subcontractor, and the subcontractor. You also might consider possibly vetting suppliers that your subs would use. Something else to consider because of the definition of what a subcontractor is.
One other thing you're going to want to do is require records retention by your subcontractors and also audit rights. As I mentioned before, a wage claim may not arise until years after the work is completed on the project. So you're going down the line, and it's 2 years after the project's been done, you're on to bigger and better things, and then all of a sudden the employees of a subcontractor come in and they're filing a lawsuit against you. One of the big flaws in Senate Bill 853 is there's no notice requirement for employees of the subcontractors. And so a general contractor may not have any clue that a subcontractor failed to pay their employees until the lawsuit is brought. There is no notice requirement. This is a massive, massive problem with this piece of legislation. And so you, as the general contractor, all of a sudden, beyond any period where you could cure the defect, are being sued. And you need to defend this claim. But you have no records because the subcontractor has them. And so you contact the subcontractor and they said, oh, you know what? We threw all that out, or we were keeping them in the basement of our house, and you remember that big rainstorm last year? Well, it all got flooded and everything was destroyed. Or, oh, we switched servers or payroll companies and now we can't get that information. Because a wage claim may not arise until years after the work is completed, you need to require that the subcontractor and any subcontractors have certain record retention protocols in place, and that you have rights to access that information upon demand, including after the fact. Because absent a requirement of certified payroll reports, You will have no information about the wages paid to employees of lower tier contractors until it's too late. To be of use in defense of a wage claim, the records must still exist at the time the claim is made, and you have to have the right to access them. As part of your own due diligence, you should also retain your own records for that same 3-year time period. But, and this is very important because under Maryland law, in these Wage Payment and Collection Act cases, if the employer has not retained the records, there is it's a rebuttable presumption that the employee worked the hours that they say they worked. And so if you don't have the records, you're going to have to go out and find employees who can testify, no, this person didn't work those hours on that day. And it gets into a he said, she said, where you've got people lined up saying, oh, I was on the job site for 9 hours on this day. And then you have to bring somebody in to say, no, on this day we were only there 7 hours because it rained that afternoon. Nobody's going to remember that. And to put on that defense, you're going to have to go out and reach out to employees, other employees of either the subcontractor or your own employees, and then basically notify them that there's been a wage payment issue, which not only may they not defend you or give you the testimony you want, they might end up joining the lawsuit.
So this is where the certified payroll records come in, so that a general contractor should insist on getting payroll records from everyone on the project. In other words, they should come from the sub to the sub to the GC, and the GC should have all of those. Is that correct?
They don't necessarily have to maintain them, and it doesn't necessarily have certified payrolls are probably the gold standard for how to handle this issue now. But short of doing that, you need to just at least make sure that your subcontractors are keeping like contemporaneous time records from their employees, whether that's daily punches, whether that's time cards the employees fill out daily, and that they're keeping those for at least 3 years at any given time, and that they're maintained in a way that you can access them if a claim is made. And so whether that's giving you the records or they preserve them somewhere, maybe everybody at the end of the project, all of the time cards go to Iron Mountain and they're stored there, but they have to be maintained somewhere in some capacity where if there's an issue down the line, you're going to be able to get them. You don't want to have to, at the inception of a lawsuit, spend your time trying to figure out, do the records exist? If so, where are they? Who has them? Have they been destroyed? And is this something that was contemporaneous, or is it something that was filled out after the fact because the subcontractor is all of a sudden saying, oh wait, the contract said I had to do this and I forgot, and now we need to cover our tracks.
Okay. So I'm going to talk about another way we can strengthen our subcontract and our sub-subcontract, and that is in the definition of what constitutes a default under these contracts. Why do we want to do this? Well, we want to do this because we don't want to continue on a situation where we have an inkling that somebody isn't paying, or we know isn't paying wages properly to the laborers on the project. We need a way to stop that, and the strongest way to stop that is to make it a term of default under the contract in which termination could occur. So therefore, be sure that in your default provisions of your subcontract or your sub-subcontract, that a failure to comply with the wage and hour laws constitutes a grounds for termination. The next way we can try to protect ourselves from these claims is in our lien waivers, is to get affirmative language in the waivers that the sub has paid for all of its labor and all of its supplies through the period in which the waiver is being issued. Now, you have that normally, but we would bolster that language to say that we certify that I've paid all of the subcontractors, and the subcontractors have paid all the subcontractors, et cetera, et cetera. So we just like to bolster the lien waiver language more to show your due diligence in fighting these wage and hour violations. Another way that there's a possibility that these claims could be insured against, if you will, is to require surety bonds from your subs or your sub-subs. The question becomes, will they be able to obtain bonding capabilities on a project, and will a bond cover the failure to pay the wages? That wages ordinarily under a payment bond arrangement would be payable, but the question is, would the treble damages and the attorney's fees be payable under a payment bond? And I think the answer to that is the current surety bonds, the way they're written, would not include those types of damages. The question therefore becomes whether a insurance company would be willing to write additional coverage into those bonds to cover these types of claims. Only time will tell with regard to that. Oh, yeah, and one more thing, of course, is that you need to review the surety bonds that any subcontractor or subcontractor provides on the project. They will be driven by the terms contained in the surety bond on these issues and others, and therefore if there's a limitations period for making claims or giving notice of claim, you'll need to make sure that you comply with those. If those notice periods are historically short, like they usually are, of 90 days, it'll be 90 days from what? I mean, if, as Greg indicated, there's no notice requirement under this law that the employee has to provide to anyone about his or her failure to be properly paid, and therefore, as Greg indicated, that you may not know about a claim for 2.5 years after the project has been completed. So be mindful of the limitations and the notice requirements that are in surety bonds.
One other source of protection and recovery that you may want to look at are personal guarantees. Depending on factors such as the subcontractor's reputation, track record, or financial strength, you may not be willing to hire that subcontractor without some additional risk mitigation factor. And so one of those could be a personal guarantee from any owners of the company, such that that personal guarantee would be triggered by any breach of any wage and hour laws or the breach of any indemnification obligation under the wage and hour laws or Senate Bill 853. Please keep in mind that if you're getting a personal guarantee from an owner and you would want to collect against their real property, you need a guarantee from their spouse as well, or any other co-owners. And so it's important that if you're going to get a personal guarantee, that you get the right personal guarantee. There's too many situations we've all seen where you get a personal guarantee from the owner of a subcontractor, they transfer all their real property to their wife, and so that when the project goes under, things go south, you then go to collect on that personal guarantee. They hold up their hands and say, I've got nothing. And you say, well, wait a minute, no, you live in this $1 million house. What are you talking about? And I say, well, no, my wife owns the house, not me. Right. And then you can't collect against it. The other idea is to have a funds control account or an escrow account. And this is something that comes from surety law, but sureties will sometimes impose the requirements of either a funds control account or an escrow account to ensure that every proposed payment to a subcontractor using contract funds is approved and that the contract funds are only being used to pay contract-specific obligations. So you could put in place something like that where portions of the money that you're paying to a subcontractor that's supposed to go to wage payment to employees, that money goes into an escrow account, and that only upon an adequate showing by the subcontractor can those funds be released to the subcontractor. Otherwise, you're going to hold on to those to pay the employees.
And another way that you can protect yourself possibly from the ramifications of this act is the Maryland Trust Fund statute. Again, Maryland Trust Fund statute applies only to projects that are within the state of Maryland. But if your project is within the state of Maryland and it's a private project or it's a state or local government project, then the Maryland Trust Fund statute would apply. And as most of you will know, the Maryland Trust Fund statute requires that persons or entities receiving payment on a project hold any of the funds that they receive on that project that are due to lower tier subcontractors or laborers to pay that money to those lower tier subcontractors or laborers or suppliers, and to fail to do so is a violation of the statute. The statute has some teeth to it in the fact that not only does the liability for the diversion of trust funds fall upon the entity that failed to pay the lower tier subcontractors, but also the individuals that were responsible for the diversion of those funds, such as managing agents, principals, owners, etc., of that company, can be held personally responsible for the diversion of those trust funds. This would be a way that if you are facing a payment, wage payment claim, that you could look to the individuals of the entities that were responsible for the diversion of funds for indemnification through the Maryland Trust Fund Act.
One of the last things I want to talk about is insurance coverage. You've got your general liability, you've got your workers' comp. Okay, well, now that there's Senate Bill 853, let's just get our wage payment insurance. Unfortunately, I don't think that's going to be an option. As of right now, there are no existing standard insurance policies that would cover wage payment claims, first of all, by your own employees, let alone by your subcontractors' employees. Generally speaking, most insurance companies don't insure against risks that you have control over. And so they're not going to insure a company to say, oh, if you don't pay your employees, we'll pay them for you. The cases where I have seen wage payment claim insurance, it's been limited to they'll provide a defense for any claim, but they're not going to cover any damages owed. Insurance companies are very reticent to get into this area. It's hard to gauge the risk. There's potential treble damages and attorney's fees exposure, and by and large, these tend to be willful violations. The cases where I have seen this kind of coverage, it is insanely expensive. You're almost paying dollar for dollar what it would cost to pay the wages. So that's really not going to be an option, and that's why you're really going to have to protect yourselves through your contracting process, through your hiring processes, because this isn't something where you're just going to be able to farm it out to an insurance company and say, well, if there's a problem, they'll take care of us. That's not really going to be available. All right, well, on behalf of ABC Baltimore, Right Constable Skeen, Doug and I thank you for your time this afternoon. We appreciate you taking the time out of your day to sit down and listen to us talk about this horribly, horribly drafted law. And, we recognize that as time goes by and as things become clearer in terms of how the courts are interpreting the law, how it's being enforced, as issues arise, you may have questions. Our contact information is on this page. Please feel free to reach out to Doug or I if you have any questions, and we will do everything in our power to steer you in the right direction.
Hey, good luck with this. It's going to require a lot more monitoring on projects and a lot more record keeping in an area that already has a lot of record keeping. But that's going to be the key, is the paper trail. So gear up for it.
All right, thank you.